All right. So, welcome to Legal Aid of North Carolina's free clinic on tenant rights. This clinic will focus on the rights of tenants who are unable to pay rent due to loss of employment or other COVID-19 related hardship, and how the COVID-19 emergency impacts the ability of a landlord to file for eviction. The clinic will also explain the protections tenants have against self-help eviction, as well as the rights of tenants who live in hotels and those who live in public or subsidized housing. Lastly, the clinic will explain what a tenant should do if the landlord isn't making repairs to the rental property. Our speaker today is Peter Gilbert, a supervising attorney with Legal Aid of North Carolina's Durham office. Mr. Gilbert graduated from Yale University in 2003 and from UNC School of Law in 2009. Upon graduation, Peter served as a fellow at the UNC Center for Civil Rights with a focus on school desegregation, excluded communities, and environmental racism. He joined the staff of Legal Aid of North Carolina in 2014, where he now leads the eviction diversion program in the Durham office. Following the presentation, you will have an opportunity to ask questions. Please keep your questions as general as possible, as we are unable to provide you with legal advice specific to the facts of your case. If you still need help following the clinic, you can call the Legal Aid Helpline and apply for assistance. The number is 1-866-219-5262. Thank you.
Good afternoon. I hope everyone can hear me okay. Thanks for that introduction. I'm glad to be here with you. And I will be taking questions throughout. So feel free to post those in the Q&A, or if you're watching on Facebook, you can post them in the chat there and Kane will relay them. So I hope everyone's doing well this afternoon. That was, we're going to cover as much of that as we can in the next hour and a half. But again, I'm Peter Gilbert and I'm glad to be here with you. I hope everyone is safe and doing well. Let's see if I can figure out how to switch slides. There we go. So as I hope you know, Legal Aid of North Carolina is a statewide nonprofit, and we help people with various civil legal needs across the state. You can reach us, and the number will be at the end, at 866-219-5262, or online at our website, legalaidnc.org. I run the eviction diversion program in Durham, which is similar to other programs we have in cities around the state. Ours is a partnership with the Duke Civil Justice Clinic, and we focus on representing tenants who are facing eviction. North Carolina and Durham in particular have very high eviction rates, and so we work in partnership with the Duke Civil Justice Clinic and the Durham County Department of Social Services to try to provide both financial assistance and legal assistance to tenants who are facing evictions in an attempt to keep folks in their homes. Legal aid also helps people with domestic violence restraining orders and getting access to benefits, foreclosures, veterans benefits, and a number of other civil legal issues. But today we're just going to focus on evictions and tenant rights. So again, this is how you can get in touch with us if you need help. If you happen to be in Durham, you can also call the Durham County Department of Social Services for financial assistance. And in many counties across the state and cities across the state, there is emergency rental assistance. And even if there didn't used to be, there's a lot more available now because of the CARES Act, and will perhaps be available due to some recently passed legislation in North Carolina. So check with your city or county, because even if there wasn't assistance in the past to help tenants paying rent, there's likely to be that assistance available now or maybe coming soon. So I'm going to start out talking a little bit about where we are now in terms of what's happened due to COVID-19 and the various orders in terms of eviction proceedings. So as you may know, the Chief Justice of North Carolina's Supreme Court, Chief Justice Sherry Beasley, has extended court deadlines to, let me go back, to June 1st, 2020. So that means that most court cases will not start happening again until next week. For the last couple of months, they've been having limited court proceedings, emergency proceedings for domestic violence protective orders, and some criminal first appearances. But most civil cases, including evictions, have not been held recently. They are going to start happening again on June 1, but the local judges, it's going to be up to the local judges to determine how and under what circumstances those hearings can be held safely. So if you have a pending eviction or know somebody who has a pending eviction, or if you're a landlord trying to figure out when your case will be in court, you need to contact your local clerk of court, because it's going to vary from county to county, or at least from across different judicial districts. So for example, in Durham County, we don't have specific confirmed information yet, but we've been told that it's unlikely that small claims court eviction proceedings will be held in June, that it's going to take longer than that before they're able to hold small claims court evictions. But that's going to vary county to county. One thing to know is that evictions often have very large dockets. It's not unusual for there to be more than 100 cases on for the same time. And they're often in the smallest courtrooms in the courthouse, in small claims court. So in many counties, that may be 100 people who would normally be in a room of, 300 or 400 square feet. And so it's understandable that given COVID-19, there may be some delay before those proceedings can continue, or they may have to be held either remotely or some other way. But that, like I said, is going to vary county to county. In addition, court filings were delayed until June 1. So if I'm going to go through the process here in a minute, but for example, if someone was appealing an eviction from small claims court, normally you would only have 10 days to do that. However, if the 10 days would have run any time between March 16th and June 1, you can still do it as long as you get it in June 1, which is Monday. So Monday at 5 o'clock is the end of the extension for court filings. So any kind of court filing that was due during the last couple of months will still be timely if it's filed by June 1st. And that includes appealing eviction judgments. The enforcement of pending eviction orders. Now, this is another issue. Because of that extension to June 1, many sheriffs decided that they had the authority to wait until June 1 to enforce eviction orders that had already been granted. These orders are called writs of possession. That varied again from county to county. So some counties went ahead back in March and enforced all of the eviction judgments that had been granted prior to March 16th, and other sheriffs did not. So there, in many counties, like most of the most populous counties that you see starred on this map, there were eviction orders that were already granted, final court orders, where the sheriff had the authority to go and change the locks and padlock the home. We expect that those may resume June 1st. It's not clear that there's any authority under the Chief Justice's order for the sheriffs to delay the enforcement of those padlocking any longer than June 1. So unfortunately, next week we do expect to see many folks padlocking their homes who had gotten a stay, essentially, due to the Chief Justice's order and the sheriff's interpretation of that order until June 1. There was also the governor's executive order, and this there was a prohibition on utility shutoffs, but it didn't prohibit the obligation to pay the bill. And there was some guidance on evictions, nothing binding, but it encouraged the clerks and the sheriffs to use their discretion not to enforce existing orders. But again, now that that June 1 deadline is coming up, we expect that many sheriffs were going to resume carrying out the eviction orders. So there's also federal legislation that I want to talk about that has a big effect on whether or not evictions can proceed right now. And this is the CARES Act. This is a moratorium that was, the CARES Act was put in place on March 27th. And some of you may have heard the president say that there was a moratorium on evictions. It's limited. So it's pretty broad, but it is limited. So it applies, first of all, to all federally subsidized housing. So that means anyone with a Section 8 voucher, anyone who lives in public housing, or any of the other multiple varieties of federally subsidized housing. So some of that is subsidized through HUD, some of it's subsidized through the USDA, and even some of it through the IRS with the low-income housing tax credit program. A couple of things to know about this is it applies to the entire property. So if you may have an apartment complex where some of the units are subsidized and other units are not subsidized. If any of the apartment units in that property are subsidized, then this moratorium applies. It also applies to any property with a federally backed mortgage. And so that's pretty broad too. There's a lot of different types of federally backed mortgages. So many people have heard of Fannie Mae and Freddie Mac, but there's also mortgages backed through the VA or through the USDA. Any type of federally backed mortgage, this moratorium is also going to apply. So what exactly is it? It's a delay on filing evictions or proceeding on evictions that started on March 27th and then runs for 120 days. So it essentially runs through the end of July. But even after that, the federal law requires a 30-day notice. So in North Carolina, under many circumstances, depending on the lease, there might not be any notice required under normal circumstances, or there might be a 10-day demand for full payment of rent that is required before they could file an eviction. But this federal law for these properties requires a 30-day notice, which can't be issued until the end of July. So this basically pushes these eviction proceedings back until about the end of August. So that's when we'll start seeing these filed. Now, some of these may have been filed already, but it wouldn't be legal under the federal act. So one of the things that that we can assist with is if tenants are facing eviction, it's very hard for the tenant to know what kind of mortgage their landlord has. In fact, these programs can be pretty complicated, and the property manager may not even know whether or not the Federal CARES Act applies. So one of the ways that I think it can be useful to have an attorney representing a tenant in an eviction case, especially now, is to find out whether or not this federal law applies. It may not be legal to file any evictions under this, if this applies, until, like I said, the end of August, and only with proper notice. Still struggling with advancing slides. There we go. So actually, let me just stop there briefly and ask if there's any questions specifically about these various orders and laws that are delaying eviction proceedings right now. I went through that fairly quickly, and it was a little bit complicated. Are there any questions about the CARES Act or about the Chief Justice's order or the Governor's executive order or anything that's delaying proceedings right now? And if you think of your question later, feel free to put that in the chat or on Facebook. So I'll keep moving then. As I mentioned in the beginning, there was already an eviction crisis in North Carolina before the COVID pandemic. So, but with the COVID pandemic, it's gotten much worse. There's been news reports that up to a third of households in the United States were not able to pay their full rent in April. I've heard from the Apartment Association of North Carolina that it may not have been that bad in North Carolina, that 90% of units in the apartments that they represent paid some rent in April. So that doesn't mean that they paid all their rent, but they paid some rent in April. But still, 10% of all tenant families being unable to pay their rent would be a lot. So there's a question in the chat about landlords getting a mortgage forbearance to give a rent forbearance to their tenants. That, I think, is the state law that was just passed. I'm not familiar with the details of that, and I'm not even sure that that has become law yet. So I will look into that, but I don't know the answer to your question. There was discussion certainly in the legislature about a program like that. So with getting back to the scale of the problem with this COVID pandemic, in Durham, there's about 60,000 rental households. This is just an example. So even 10% of them not being able to pay their rent in a month would be about 6,000 folks facing eviction. If it's as high as a third, it would be 20,000 folks possibly facing eviction. And that's millions of dollars in unpaid rent for each month that goes by for folks who've lost their job. So that could be, we could be seeing, when the courts reopen, a much higher eviction rates than we've seen historically. This will show you a little bit about just where we were. This is for Durham again, which is just an example. Durham used to see about 9,500 or 10,000 evictions a year. If this rental crisis is as bad as we anticipate, we could see 2 or 3 times that many or even more this year. March, we saw roughly twice as many evictions filed as we normally see in March. Usually February and March, we have very low numbers of evictions because people get their tax refunds and they get caught up on their rent. So March is usually actually the lowest number for evictions. But we saw, usually it's in the 400 or 500 range because it's the lowest month. But we saw more than 900 evictions filed this March. In April, we saw very few evictions filed. And I suspect that because the landlords knew that the courts weren't open and their case wouldn't be heard, there was not much to be gained in filing the eviction now, that they're waiting to see, there's no court proceeding right now to deal with the eviction. So there's not much incentive to file right now. So I expect that once there's a system and the courts reopen, we'll see a wave of evictions. I'm going to start talking now just generally about landlord-tenant law and how it works. A lease is the contract. It doesn't have to be written. It can be an oral lease. Under certain circumstances, if it's a very long lease term, it might have to be written. An eviction is not the same thing as the termination of a lease. So before you can evict somebody, you have to terminate their lease. And that's what the notice is usually, the notice of lease termination. Some leases allow for basically an automatic termination or an automatic forfeiture under certain conditions. But the eviction, when I use the word eviction, what I'm talking about generally is the court proceeding. And that starts when the landlord goes to the courthouse or the property manager goes to the courthouse, and it's actually a lawsuit. They file a lawsuit against the eviction, against the tenant, I'm sorry, and then the tenant is served with a summons and a complaint. At the end of the process, then, if the landlord is successful and is granted possession of the home through the court process, they will be locked out by the sheriff. So first step is the sheriff serves the summons and complaint filed by the landlord. That's the summons says you've got to be in court on this day and this time, and the complaint is essentially the lawsuit itself. They were seeking to evict you, gives the reason why that they're seeking to evict you, and then various other factual allegations, the term of the lease, the amount of the rent, and things like that. It's got to be signed by the landlord, or it can be signed by a property manager representing the landlord. Shortly after that, the case will be set for small claims court. Under normal circumstances, it would be within about 10 days. Now, of course, the courts are delayed, so a landlord can still file the summons and complaint, but it may not be scheduled depending upon the time. They may schedule it and then continue it, or they may not be scheduling them at all until they know when and under what circumstances they'll be reopening the courthouse. Once it's scheduled, then the tenant will receive a summons. At that first court date, the tenant can request a continuance, but generally, unless the landlord agrees to the continuance can be no more than 5 days. So some people who are used to maybe the criminal courts or other court proceedings are used to things that take many months to resolve. That's generally not the case with evictions. These happen very, very quickly. And continuances are often denied. There's no right to having a continuance by either party. Although I will say that when a lawyer represents the tenant and requests a continuance, you're much more likely to get the continuance, unfortunately, in my experience, than an unrepresented tenant requesting a continuance. And then the hearing's held, either that first setting or after the continuance. And if the landlord has the burden of proof, so the landlord has to prove that they are the landlord and that there was a lease, and that also the facts or the non-payment of rent or whatever the circumstance is that would entitle them to terminate the lease and evict the tenant. So the landlord has the burden of proof and has to put on evidence, just like any other court case. Most of the time, the landlord is able to prove their case, and they receive a judgment. That judgment gives the tenant 10 days to appeal to district court. So these cases start out in small claims court in front of a magistrate, relatively informal, but like I said, often small and crowded courtrooms. But the tenant can appeal, or the landlord, whichever side didn't win, can appeal the case then to district court and even ask for a jury trial and have a more formal court proceeding. So the small claims court trial is usually held within 10 days after the filing of the complaint. The judgments become final 10 days after the hearing in small claims court, unless an appeal is filed. And then after, on the 11th day, so say for example, the small claims court hearing was on June 1st and the judgment was granted for the landlord, then on the tenant would have until June 10th to file the appeal to district court. And on June 11th, the landlord could go back to the clerk's office and file for what's called a writ of possession. A writ of possession would be the order that the sheriff would use to then padlock the home. The sheriff, under normal circumstances, without the delays due to COVID, would need to enforce that within about 5 days. So it's very quick, and there's a statutory requirement that the sheriff act on that very quickly. So just to give you some example, if you were late on your rent in June, most of the time rent is due on the 1st and it's late after the 5th. On the 8th, the landlord could go and file the lawsuit, the summons and complaint. That could be heard as soon as, say, the 15th, 16th, or 17th of June. If it was heard on the 16th, then the judgment would be final on the 26th, and the sheriff could get the landlord could file for a writ of possession on the 29th of June, and it would probably be executed sometime the 1st or maybe 2nd week of July. So basically, within about a month from being late on your rent, the sheriff can come and padlock the home. It can even happen within the same month. So some tenants have a belief that they have 30 days before there can be a lawsuit. That's generally, that's not the case, generally. As I already mentioned, after small claims court, you have a right to appeal. You normally would have to pay a filing fee to appeal, but if you are indigent, so if you and you can prove that you're indigent if you receive food stamps or SSI, or if you're represented by Legal Aid of North Carolina, then the cost of appeal is waived and the case will be set for a case in district court. And that depends upon the county. That's often the following month, but it could be as much as 3 months later before it's on district court calendar. Now, if you lose in small claims court, a tenant loses in small claims court, they can stay in their home during the appeal, but they have to pay their rent on time to the court each month as a rent bond. And if they're not indigent, then you have to post the full amount of rent in dispute. So if the magistrate found that you owed $3,000 in back rent, you'd have to pay that full amount to stay in your home. But if you're indigent, if you can show you can't pay, then you would only have to pay the rent going forward. If you don't appeal after 11 days, as I said, the sheriff will come and put a notice on the door saying when they're going to come and padlock the home. when the sheriff is coming to padlock, there should be a notice left on the door of when they're coming. They're not going to give you a lot of time to move your stuff. So try to have your stuff, at least your important belongings and things like that, ready to go pretty quickly. But even after the sheriff has padlocked the home, you have 7 days to make arrangements to go and pick up your stuff. So just in summary, the landlord must follow the court process and obtain a court order. It is not legal, and I'll go over this in a minute, it is not legal for a landlord to evict you on their own. They have to use the court process and the sheriff. You can't just change the locks or shut off the utilities or board up the windows. And you can't agree to not use the court process. You can't put in your lease that the landlord can change the locks at any time or something like that. It's got to go through the court process as a matter of normal law. Briefly about security deposits, how much of a security deposit can be required is set by statute, and it depends upon the length of the lease term. Generally, for most leases, the most you can require in a security deposit is 2 months. You've got landlords, they almost never do this, but they are required to provide written notice of which bank is holding the security deposit. The landlord can't just put the security deposit in their wallet. And after 30 days of the tenant moving, the landlord is required to either give a written accounting or return the security deposit, or under certain circumstances, they can give an interim accounting. If they don't know yet what all the expenses are, they can give an interim accounting after 30 days and have to give a full accounting after 60 days. And if they don't do those things, then they have to return the full security deposit. They can't later come up with what they spent on it if they didn't provide that accounting. But they can keep security deposits for a number of reasons: to cover back rent, to cover costs for repairs beyond normal wear and tear, lost rent, even possibly expenses for finding another tenant, or court costs related to eviction. So we've got a great video here that I encourage you to check out, and we'll be happy to share this presentation. But if you go to Legal Aid's website or our YouTube channel, you're going to find some fantastic videos, animations that our outreach team has created, including one with more specific information about security deposits. A little bit about late fees. Late fees are also set by statute. They're capped by statute, so the lease doesn't have to charge a late fee, but there's a maximum amount that can be charged, which is either $15 or 5% of the monthly rent. And the lease, if you're going to charge a late fee, the lease has to say we're going to charge a late fee, but it can be no more than $15 or 5% of the monthly rent. And it can also only be charged one time. So for example, if I'm late on my May rent, my landlord can assess a late fee. If I pay the rent, but I don't pay the late fee, then the landlord cannot say, well, you're late on your June rent too, because you didn't pay the late fee, and charge another late fee for June. You can only assess the late fee once. And violations of this or the Security Deposit Act can actually constitute unfair and deceptive trade practices, or even acts of unfair debt collection, which are covered by a separate law in North Carolina that allow additional damages for the tenant. There are some other fees that the landlord can charge if they have to take you to court, and if the lease allows it. They can charge fees for the different stages in the court process. Now, they can only charge one of these fees. They can't charge all three of them. And they can also charge reasonable attorney's fees. And that was a change to the law a couple of years ago to clarify that landlords, if it's in their lease, can actually charge the tenant the attorney's fees related to an eviction. Now, if the rent is subsidized, meaning that your rent is based upon your income, which is true for most public housing tenants or Section 8 voucher holders and some other types of federally subsidized housing, then the amount of the fee is based upon the tenant's share of the rent only. So if, for example, you had a Section 8 voucher and your share of the rent was $300, then the late fee is based upon the 5% of the $300, not 5% of the total rent, part of which is paid by the housing authority. So there are four legal basis for eviction. There are basically 4 reasons why a landlord can seek to evict somebody. And there's on the complaint, they're going to specify one of these 4 boxes. One of them is non-payment of rent, which means that you didn't pay your rent and they have to give you a 10-day demand. So they have to say you owe this amount of rent and you have 10 days to pay it. And if you do not pay it, then we can take you to court and seek to evict you. That's not true under all situations, depending upon what the lease says, but that's the default rule if the lease doesn't specify otherwise. If you've stayed over after the end of the lease term and you've gotten proper notice. So most leases are periodic tenancies which renew automatically, and the law specifies how much notice you have to give. For a year to year, it's generally a month. For a month to month, it's generally, I think it's a week. And for a week to week lease, it's 2 days. But you've got to give the notice before the end of the lease term. So for example, if I'm in a month to month lease that starts on the 1st and ends on the 31st of the month, the landlord only has to give me a week notice, and it has to correspond with the end of the lease term. So the landlord can't give me a week notice on the 15th of the month saying you have to be out by the 22nd. That would be not a valid notice. So that's the second basis for eviction, is you've stayed after the end of the lease. The third, and this is the most common one, is breach of the lease, that there is some rule in the lease that you broke, that the landlord has reserved what's called the right of reentry. So in general, the remedy for a breach of the lease is not eviction. It would just be money damages, like the remedy for most court cases. But if the lease specifies that if you break this rule, we can evict you, and it has to be spelled out in the lease, then breach of lease is a basis for eviction. And most corporate leases, most of the leases that you'll see, will say that a breach of the lease, or almost any breach of the lease, is a basis for an eviction. Now, breach of the lease can include not paying your rent. That's one of the contractual requirements of the lease, is that you pay your rent. So most leases now will say that if you don't pay your rent, that's a breach of the lease and we can evict you immediately. So you don't have to give the 10-day demand that I listed under the first one, non-payment of rent. This is a bit confusing, which is one of the reasons why we encourage tenants to reach out and get representation if it's available, or at least call our helpline so that we can explain to you the reason and the terms why you're being evicted. In addition to these, certain criminal activities, this isn't all criminal activity, but drug-related crimes more serious than simple possession, or crimes of violence, something that threatens the health and safety and the welfare of the community, can be a basis for an eviction as well. So I'm going to go through those 4 bases and talk a little bit about the defenses. What do you do to defend yourself if you're facing an eviction for one of those reasons? But before I do that, it looks like I've got a question. The first question I see is, would Lance limited representation via lawyer on the line qualify as representation for waiver of fees? I believe that it would. The waiver of the fee is based upon, are you represented by someone who is an organization whose mission is to represent indigent people. And so I think that the pro bono attorneys who cooperate with Legal Aid of North Carolina, there ought to be a workaround then, but it is actual representation. Lawyer on the line is generally not appearing in court. So for the most part, the attorney has to appear in court in order to qualify as representation for the purpose of waiver of fees. The second question that I see here in the chat says, can a writ of possession order ever come before a decision in a summary ejectment action? And the answer to that is no. The writ of possession order can only come after the court decision. Now, there are other writs of possession that don't come up in eviction proceedings. So there are writs of possession that can be issued, for example, pursuant to a foreclosure action, which may be issued by the clerk, but that would happen after a foreclosure case had been decided instead of an eviction case. But otherwise, no, the writ of possession order can only happen after the small claims court action. All right, I think I've addressed those. I'm going to move on to these. One more. Will the presentation be made available to the public or to the registrants? Yeah, I think we can work that out. And I know that the video of this presentation should be available both on Facebook Live and on YouTube, but I'm happy to make the slides available as well. So non-payment of rent, this is not the breach provision, but the statutory provision, which is North Carolina General Statute 42.3. The defenses. So one defense is just to pay the rent and the costs. And so that's why most leases and most landlords now file, if you don't pay your rent, they'll file it as a breach, not as this statutory non-payment, because under the breach, you don't have the defense of just tendering your rent. Whereas here, if it's filed under 42.3, the tenant can just pay it anytime up until court. And if they pay it, then the case should be dismissed. Secondly, the landlord has to actually make the demand and wait the 10 days. So they've got to say, you owe this much rent and you've got 10 days to pay it. And only then can they file a court case. And then the third defense that we see is that the tenant may have counterclaims. They say, actually, you owe me for such and such. And that money can be set off against the back rent that's owed. Most often we see this arising when the conditions are poor and the tenant may have damages related to the poor housing conditions, which I'm going to go over in some detail towards the end of the program. All right, defenses to a holdover claim. So the holdover claim was the one that I was talking about where the term of your lease has expired, your lease is over, and they've given you notice. And if you stay after that notice, then they can file for an eviction. But basically, the notice has to be right is the main defense. In addition to making sure that the notice is what is required under the lease and under the statute, if the landlord accepts rent into a new period. So if the landlord sends you a letter and he says your lease is up on June 30th and I am not renewing it, but then you pay your July rent and the landlord accepts your July rent, then they can no longer evict you because they've basically accepted the rent for the new period. A fourth defense that comes up here is what's called retaliatory eviction. So the one defense to eviction is a landlord cannot evict a tenant who is lawfully exercising their legal rights. One way that we see this come up a lot is if the landlord is not making adequate repairs or the tenant thinks the landlord's not making adequate repairs, maybe the tenant calls the city inspector and requests an inspection. The landlord doesn't like that. They don't want the city inspector there. And so the landlord says, okay, fine, I'm not renewing your lease next month. Many people have been, it's common for a lease to be an initial 1-year term and then to roll over into a month-to-month lease after that. And so many people have been in their homes for many years, sometimes more than a decade, and all they actually have is a month-to-month lease. And so we see this situation sometimes where maybe they'll call and they'll complain about a fair housing violation or housing discrimination, or maybe they'll call and they'll complain to the government or the city about a conditions issue. And then the landlord says, fine, you want to call the city inspector? I'm not renewing your lease. Well, they can't actually do that. That would be in retaliation for the tenant lawfully exercising their legal rights. And that's another defense to eviction. So the defense to the breach of lease claim, and this is the most common claim that we see, which is that you broke some rule, or the allegation is that the tenant broke some rule under the lease. And so the first defense is just that no, the breach, it didn't happen, right? The landlord has to prove that it happened. And they have to prove that it happened with non-hearsay evidence in a regular court proceeding. So they can't just show up and say, well, the neighbor said this happened. They've got to actually bring the neighbor into court as a witness. so that they've got to be able to prove that whatever the event was happened. Now, most often the breach that's being alleged is non-payment of rent. So it's enough for the property manager to come in and say, I didn't get the rent. Rent wasn't paid. Another defense is waiver. So for example, if I had a dog and my lease said you can't have dogs, but my landlord knew about my dog and saw the dog the day I moved in, and the landlord kept taking my rent for months, then the landlord can't come back later and say, I'm going to evict you because you have a dog. If the landlord knows about the breach and continues to accept rent, then the landlord can waive the right to terminate the lease based upon that breach. Now, if the lease has specific language that says we're not waiving our right to terminate, then that defense wouldn't apply. I already talked about retaliatory eviction. And then proper notice. Now, this comes up most often in the context of subsidized housing, where in order to terminate a lease, I won't go into the different types of subsidized housing, and it does vary a lot depending upon the type of subsidized housing. But there's got to often be what's called good cause to terminate the lease, which means that it's got to be a substantial lease violation or repeated minor violations. You know, having one minor lease violation might not be enough under federal law to terminate a lease. And so in that situation, there may be additional notice and even additional hearing requirements under the federal regulations before a subsidized housing lease can be terminated. I saw in the chat a question about damages for self-help evictions. I'm going to talk about self-help evictions a little bit more in detail in a second, and I'll be sure to cover damages there. But I want to finish the last on the defense to evictions. Again, I mentioned the criminal activity as a basis for eviction. One defense is simply that they didn't do it, or the landlord can't prove that they did it. Another is a statutory defense that the tenant was essentially innocent, right? That there was a guest or another household member that may have engaged in the criminal activity, but the tenant had no way to reasonably know that that was likely to happen, and they did everything that they could to cooperate with law enforcement, that sort of thing. That can result in a partial eviction of the household member only. So, for example, if you had no idea that your grandparent that you were letting live with you was secretly smuggling guns, and there was, absolutely no way you could have known, and when the police show up to arrest granddad and his rifles, you consent to the search and all of that stuff, then the court can order just the eviction of the offending family member as opposed to the entire household. So the tenant claims free legal lockouts, and I hope that this goes to the question that was in the chat. As I mentioned earlier, it is illegal for a landlord to seek to evict someone without going through the court process, and that can include changing the locks or boarding up the windows or disconnecting the water, anything like that. They can bring damages for money owed and return of property. So you might have a conversion claim there that essentially the landlord has stolen your property. If they lock you out and they don't give you your stuff back, they've basically stolen your stuff. So you've got you may have claims there, or if they throw your stuff out on the street and it gets stolen or damaged by being exposed to the weather, you may also have claims for your lost property that way. You may also have claims that for breach of contract. The lease is a contract and you're entitled to the benefit of the bargain. So you're entitled, you can have claims if you had to stay in a hotel, or you had costs associated with moving, or costs associated with finding another home. Maybe you had a good deal and you got locked out, and the next apartment you find is another $200 a month more. The landlord could be liable for all of those damages. Lost food, having to eat out, any of the consequential damages of the illegal eviction. In addition, landlords may be found liable for unfair and deceptive trade practices by locking you out without going through the court process. And that means that they may be liable for 3 times the actual damages. So if they lock you out without going through the court process, and you've got, say, $1,000 in personal property that you lost, and 5 nights in a hotel for another $1,000, and eating out a little bit, they may have to pay 3 times those total actual damages. In addition to that, when we learn about illegal lockouts, one of the things that you can do is you can actually go to court and get an injunction restoring you to possession. So that's something that we've assisted many tenants with who are locked out illegally. We can actually get a court order that restores them to possession. So I hope that answers that question. One of the things that we've unfortunately seen a lot of during this COVID pandemic are illegal lockouts or self-help evictions from hotels. So just because something's called a hotel doesn't necessarily mean that the law is going to treat the resident as a hotel guest. In fact, the law may treat the hotel resident as a tenant. And so some of the factors that the courts will look at to decide if the resident of a hotel is a tenant or a guest is, do they have any other residents, right? How long have they been there? How often do they pay rent? Is it called rent? Are there services provided? It's sort of a totality of the circumstances test, right? If I go to Atlantic Beach for the weekend and I stay at the Marriott and they wash my towels and they put a chocolate on my pillow and I get room service, well, the court's probably going to say, and I have a mortgage in Durham where I live most of the time, then the court's going to say, you're a guest. If you don't pay your bill, they can just change the lock. They don't have to sue you in court. On the other hand, if I'm staying in a hotel and I don't have any other home and I've been there for months, and every week the owner of the hotel comes by and says, where's the rent? You owe me a week's rent. And nobody does my laundry for me and nobody's putting a chocolate on my pillow. Well, then I'm probably a tenant. And it doesn't matter if it's a national brand name hotel or not, or the landlord says I'm the such and such hotel or motel or rooming house. Under those circumstances, you're a tenant and you can only be evicted by going through the court process. So one of the things that we've unfortunately seen a lot of across the state is people being illegally locked out of these hotels because they're not able to pay their rent. And a lot of poor people do live in hotels because there's no credit check generally in some of these hotels. So they may not, if they have prior evictions on their record especially, they may not be able to find a regular apartment and end up living in these hotels, often paying what is to my mind astounding rents, $500 a week, paying $2,000 a month to live in one room with no kitchen, sharing a bathroom with the rest of your family. But it's sometimes the only thing that's available. So I'm going to stop there before I go on to fit and habitable conditions and ask if there's any questions.
Hi, Peter. We actually do have a couple questions from Facebook. So the first one is, I did not pay rent for April or May, and my landlord has said he will evict me on Monday. I'm getting some money from a church, but he is refusing to accept it. I have 3 small children, and he is also refusing to make repairs, including a broken air conditioner. What are my options? So again, as we said at the beginning, unfortunately, I cannot give you specific legal advice about your specific case. I will say that I'll repeat what I said, which is that you can only be evicted by going through the court process. So legally. So your landlord would have to go on to file a case in court and then go follow the court procedure. If you have not, in fact, paid your rent, most likely they would be successful in that court procedure. But as we said earlier, you can offset the rent that's owed by counterclaims for failure to make repairs. So what I would encourage you to do is to contact Legal Aid of North Carolina so that we can, in fact, give you more specific advice about the facts of your specific case. And again, that number is 866-219-5262.
And you can also find it online at our website, www.legalaidnc.org. And Kane, if you could put that information in the Facebook chat, I'd appreciate it. What was the other question?
So this last question is, if a renter has been given 67 days notice under 7-day statute to vacate and upon termination of the federal moratorium, will the sheriff be able to remove default renters?
Well, once again, I'm not going to address the specific facts of the case, but in any case, you have to, the only way that the sheriff will enforce an order is after a court proceeding. There is no way to avoid going to court. That's the only lawful way to carry out an eviction in North Carolina. And if the Federal CARES Act applies, which it doesn't to all homes, but it does to some, then those evictions can't be filed until the end of August, and you can't even give the 30-day notice until the end of July. And so that federal act, if it applies, would trump whatever's in the lease. So even if the lease says you have to give a 7-day notice, or even if North Carolina law says you have to give a 7-day notice, if the property is covered by the CARES Act, then you have to give the 30-day notice that's required as a matter of federal law. Were there any other questions?
No.
Okay. Then I'm going to move on now, and the next section that I'm going to cover, and this may apply to one of those questions, is fit and habitable conditions. So we've mostly been talking about the landlord's potential claims against a tenant for eviction, and now we're going to kind of switch gears and talk about the tenant's rights and the landlord's obligations. So the first and main obligation is that they have to maintain the home in fit and habitable condition. And they actually have to both deliver and maintain. That means that when you first move into the place, it's got to be in fit and habitable condition. And then it's the landlord's responsibility to keep it that way during the course of the tenancy. And it doesn't matter what the lease says. You cannot rent a home as is in North Carolina. It has to be habitable and meet these basic conditions. First and foremost, it has to obey the local housing code, if there is one. Now, in most cities in North Carolina, there is a housing code, and in many counties, but in some of the more rural counties, there's not. So if there's not a housing code, then it's got to obey what's laid out in state law and has been defined by the courts as fit and habitable condition. So basically what it means is the fundamental aspects of the home have to be kept in fit and habitable condition. So the plumbing, the electrical, the walls, the doors, the ceilings, all of that stuff has to be in good, safe working order. Specifically, there have to be smoke detectors and carbon monoxide detectors. Now, generally, the landlord has to provide a battery at the beginning of the tenancy, and then after that, it's the tenant's responsibility to keep up with the batteries on the smoke detectors and the carbon monoxide detectors. The general rule is some things have to be provided by the landlord. So heat, plumbing, electricity, those are non-negotiable. The landlord has to provide those. Other things don't necessarily have to be provided, but if they are provided, they have to work. So for example, under the law, a landlord doesn't have to provide the stove, doesn't have to provide an air conditioner, but if it's there when you rent the home, then the landlord has to keep it working. So if the landlord provides a washer and dryer, they've got to fix it and keep it working. If the landlord provides an air conditioner, they've got to fix it and keep it working. There are 12, quote, imminently dangerous conditions. This includes electrical issues, ceiling leaks, lack of a operable functional heat, lack of operable toilet. Those are things that the landlord's got to repair right away, not something that can wait on. And that also includes infestations, insect or rat infestations. So here are those 12 dangerous conditions. These are the types of things that are seen as very serious under the law, and as soon as you give your landlord notice, they've got to fix it within a reasonable time. Now, a couple of these that I want to point out and talk about specifically rat infestation as a result of structural defects. So generally, under most housing codes, if you live in a multi-unit building, like an apartment building or even a duplex, then the assumption is that the landlord is responsible for infestations, because it's hard to tell which unit the rats or whatever came from. If, however, you live in a single-family standalone home, then the law may assume and the housing code may assume that the tenant is responsible, unless there is some structural defect. So, for example, if you show that you've got holes in the floor or holes in the foundation where the rats are getting in, then that's going to be the landlord's responsibility, not the tenant's responsibility. One last thing that I want to point out, we get a lot of calls about mold. Often the presence of mold itself is not a code violation or an imminently dangerous condition, but the source of the moisture or the water may be. So excessive standing water, flooding problems caused either by inadequate drainage or plumbing leaks, those contribute to mold and insects, and those are imminently dangerous conditions. So the housing codes, many of them won't specifically say mold, but they will say the various causes of moisture. Now I see a question in the chat about bed bugs and the dispute between the landlord and tenant as to who is to blame for the infestation. So in most cities that have a housing code, this includes, I know, Raleigh, Charlotte, and Durham, if it's a multi-unit building, then the presumption is that the landlord is responsible. So the landlord can blame the tenant, but the law is going to hold the landlord responsible for treating for bed bugs or roaches or any other infestation. If you live by yourself, the assumption, meaning in a standalone home, the assumption is that the tenant is responsible. Now, in both cases, those are simply presumptions and they can be rebutted. So, for example, if it's an apartment building, but the landlord, you know, like I said, if it's an apartment building, the assumption is the landlord's on the hook, but the landlord may come in and have an exterminator testify and say, listen, we have never had bed bugs ever in the past, and I've been doing inspections there for 12 years, and I saw tenant Smith pick up a mattress on the side of the road and bring it into their home. Well, maybe the landlord can overcome the presumption and can, in fact, require the tenant to pay. On the other hand, if you are in a standalone home and the assumption is that the tenant is responsible, but you can prove, hey, I just moved in January and I called the Orkin man and he said, yeah, I've been treating that place for bed bugs for the last decade. They just won't go away. Well, even though the presumption is that the tenant would be responsible because it's a standalone home, you can overcome that and say, I've got evidence that there's been a long time problem long before I moved in. It's really the landlord's fault. Or, you know, the landlord provided the furniture and the first day I moved in, there were bed bugs, something like that. I also want to say that there are specific federal regulations, again, when it comes to bed bugs in subsidized housing. And so generally in subsidized housing, the landlord, the housing authority or the apartment complex is going to be responsible for the bed bug treatments and usually cannot bill the tenant for the extermination treatments. All right. Kane, any other questions on Facebook?
No, we don't have any on Facebook right now.
All right, just let me know if we do. So what do you do if you've got an issue with the conditions of your home? What are the first things you should do? Well, first of all, you should try to keep your home clean, right? That's common sense, but a landlord may, a tenant may be responsible for damages, or a landlord may say that a tenant's responsible for damages caused intentionally or negligently by the tenant. So generally a tenant is not responsible for the condition. The landlord is responsible for maintenance. But if if I punch a hole in the wall, well, I'm responsible for that. Or even negligent damage, right? If I go out of town for a month and I leave all my windows open and it rains in and everything gets moldy, well, that's not the landlord's fault. That's my negligence. So the tenant may be responsible for their intentional or negligent acts. But assuming that something just broke and it wasn't the tenant's fault, first thing you got to do is you got to tell your landlord right away. It's always best to communicate in writing. Text message is okay, or email is okay, but a lot of people may change phone services, or you may change phones and lose those text messages. So if you are going to use text message to communicate with your landlord, take a screenshot and try to save that. But you want to save all those communications, because if you ever end up in court, one of the things you're going to want to be able to show is, I've been complaining about this since, a year ago, right? Because you're only going to be awarded damages from when you reported the problem in a lot of situations. So you want to report the problem, you want to do that in writing. Go ahead and take pictures of the conditions and document any damage to your property. And if you've got excess utility bills, say there's been a water leak that's gone on for months and you end up with a $500 water bill, or your heater's not working right and you end up with a $1,000 heating bill, you want to keep those bills and any receipts or expenses that you have. And take pictures, like I said. And then if after you tell your landlord, hey, the ceiling's leaking, and you give them a few days and they don't fix it or they don't do anything about it, then you should call and request an inspection by your city or county housing inspector if you have one. I do not suggest that you withhold rent. In North Carolina, you have to continue to pay your rent until a court orders that you don't. So the tenant's obligation to pay rent is independent of the landlord's obligation to make repairs. But the opposite is true too. So if your tenant is not paying rent, that doesn't mean that you don't have to make repairs. If a tenant isn't paying rent, the landlord still has the obligation to provide a fit and habitable home, or to take the case to court for an eviction. All right, we have an anonymous question. Termites in a duplex leasing company said the issue on me, and the flooring is unstable in the kitchen above. I've also asked many times over the years for them to come and check the pipes, especially under the kitchen sink. So again, I'm not going to comment on the specific facts of that situation, but I will say that it sounds like you've got some severe issues, and generally, I don't see how a tenant would be responsible for termites. So you need to put your complaints in writing to your landlord about what needs to be fixed, and make sure you keep a copy, and then go ahead and call for a city inspector. Those sound like pretty serious issues, and so you're going to want to go ahead and get the city inspector out there. In addition, you can call Legal Aid of North Carolina, and we are able to represent people in these cases from time to time. But generally, if you did call Legal Aid, the first thing we're going to do in most situations is to suggest that you request an inspection by the city or county housing inspector. Because if the case does end up in court, a lot of times the inspector is going to be a more compelling witness for the court than simply a tenant. So you put your complaints in writing, the landlord knows there's a problem, they're not fixing anything, you've called the city inspector, maybe they failed the inspection, but the landlord's still not doing anything. What do you do then? Well, you can sue your landlord for damages if they don't make the repairs. And the damages that can be awarded include money damages. So first is the rent abatement. Now that's the difference between the rent paid and the fair market value of the home in its actual condition. So say, for example, my rent is $500 a month, and I've been paying my rent despite the terrible conditions, but I don't have heat, and I haven't had heat all winter. Well, the court might say an apartment without heat is equivalent to a storage unit. Really the fair rent for that is $100 a month, like a storage unit, not $500 a month like an apartment. And so the court could award you the difference between the rent you actually paid and what the unit was worth, the home was worth in its actual condition. Also, consequential damages. I mentioned the excess utility bills that sometimes happen as a result of failure to maintain a property. Lost property, the ceiling caved in, and all of my Armani suits were destroyed, and the landlord might be responsible for that. Or hotel bills. If I'm if I have to leave, if things are so bad that it's not safe for me and my family and I got to go stay in a hotel, landlord could be responsible for those. Future rent reduction. So as I said, you shouldn't stop paying your rent on your own, but you can go to court and the court could order your rent to be abated going forward. So the court could say, landlord, until you get this place fixed and it passes code, the tenant doesn't owe you any rent, or they only owe you $50 a month or $100 a month or half, or whatever the court says is fair. So the rent can be reduced by going to court. Now, treble damages. If the landlord knows about the problems and continues to demand the full rent without making any attempt at repair, then the court may find that that is an unfair and deceptive trade practice. And just like we talked about with the self-help evictions or the illegal late fees, the court could treble those damages and in fact award attorney's fees as well. So the court could require the landlord to pay the tenant's attorney's fees. And in some situations, we've even gotten injunctive relief where a court has ordered a landlord to make repairs. So I'm going to stop there. Are there any other questions about these habitability issues or a landlord's obligation to fix and repair properties? All right, I will keep going. There's just a couple more slides, some specific issues that I'm not going to go into in detail, but I want you to know that are out there. Under the Violence Against Women Act, there are special protections for tenants who are victims of domestic violence. One of them is that the landlord can't refuse to rent to you or terminate your lease simply because you're a victim of domestic violence. Often we'll see this come up where a landlord will say something like, well, the police are always there. They're a nuisance. You know, the police have been there 5 times this month, and that's why they're trying to evict someone. And often the police are there because the tenant is a victim of crime, most often domestic violence, not because they're somehow causing the disturbance. And so a landlord can evict someone for being the victim of domestic violence. In addition, if someone is a victim of domestic violence, and especially if they've gotten a domestic violence restraining order or gone to get a safety plan through an advocacy agency, which I highly recommend, the landlord may be required to change the locks very quickly, although the tenant will have to pay for it, but the landlord would have to change the locks very quickly. Within 48 hours of the request, within 72 hours if the perpetrator is also a tenant. So if they live together, but the court usually in the 50C or 50B domestic violence protective order, 50B, may award possession of the residence, the landlord will have to change the locks. And the tenant can get out of the lease early. If they're not safe there and their safety plan or their protective order says they're not safe there and they need to move, then they can get out of the lease early without having to pay the rent through the end of the lease. One other law that I just wanted to bring up that comes up with landlord-tenant law is the Fair Housing Act. So it is illegal to discriminate in any aspect of rental housing on the basis of these 7 protected classes: race, color, national origin, religion, gender, sex actually is what the law says, familial status, or disability. This can come up as a defense to an eviction. For example, if say you're being evicted for having a dog, and that's a breach of the lease. If the dog is a emotional support animal or a service animal, and they're applying the pet policy to you, then that might be a violation of the Fair Housing Act, because under the Fair Housing Act, those medical animals that are required for people with disabilities are not pets, right? And so a disabled person is entitled to use and enjoy the property the same as a non-disabled person would be able to, and so can't be evicted in that way. So it could be a defense to an eviction, or you can also file an affirmative complaint or a lawsuit. So most often we see these cases come up when it comes with disability, failure to grant a reasonable accommodation or a reasonable modification. We also see a fair number of these cases when it has to do with familial status discrimination. Some landlords don't know that that is illegal, And so a landlord might say, you know what, I don't want kids here. I'm not going to rent to you because you have kids. That's actually illegal under the Fair Housing Act, but not everybody knows that that's illegal. You can always call legal aid for assistance. We have a special project that specifically focuses on fair housing issues. You can also call the North Carolina Human Relations Commission, and many cities have their own human relations departments as well. All right, just a couple of general tips. We're getting to the end here. Read everything, and if you don't understand it, ask for clarification. You have the right to negotiate. When you're signing a lease or you're moving in somewhere, you don't have to just sign whatever lease the landlord puts in front of you. You can actually say, you know what, I'm not okay with paragraph 17. Can we strike that? And it really depends on the situation. In a lot of cities, it's a hot market, or at least it was before the COVID-19. And I think a lot of corporate landlords would say, take it or leave it. You know, you either sign the lease or we'll find another tenant. But you can try. You want to keep notes about your various interactions. Keep all of your correspondence in writing. So I suggest you get a folder and keep your lease in it. Keep your rent receipts your money order stubs in there, and any notices you get from your landlord. Try to keep all of those things. Lawyers love paper, and I hope that your tenancy goes well. But if you ever end up with needing our assistance, we're going to want to see every scrap of paper that's ever passed between you and your landlord. Same thing with photographs. Take the photographs and save them. When you're moving in somewhere, one final tip. Make sure that you do a walkthrough inspection with your landlord of with your landlord of the unit you're actually going to be renting. Sometimes you'll show up to see an apartment and they'll say, oh, unit A is not ready yet, but we'll show you unit D. It's exactly the same. I would recommend you don't, rent unit A not having seen it, that you're going to want to do that walkthrough inspection. You're going to want both you and your landlord to sign off on the inspection sheet. And they have to deliver the apartment in fit and habitable conditions. So if it has things that need to be repaired, they need to repair those before you move in. It's got to be delivered in fit and habitable condition. We've got a question in the chat which says, did you say as a landlord, I cannot say no children as a tenant? Yeah, that's generally you can't. There is an exception to the Fair Housing Act if the landlord also lives there and it's like a mother-in-law apartment or something like that. Then it actually is legal to discriminate on any basis. So if I'm renting out the basement of my house and I live there, then I could discriminate on any basis that I wanted to. But other than that, in general, you can't discriminate on the basis of familial status. Now, there are some other exceptions to it. There's some subsidized housing that is specifically for elderly and disabled families, and there are federal laws that allow that. But in general, you cannot discriminate in housing on the basis of family status or sex or anything like that. All right. So once again, this is how you can get hold of us if you need assistance. That's the legal aid hotline number, and that is the website where you can also apply for our assistance. And if you need assistance in your rent, I would encourage you to contact your local government. As I said, many social service offices that didn't have rent assistance historically may now have it due to the various legislation that's passed under the CARES Act. So it's worth checking even if you don't think that they've got assistance, or they may be able to point you in the direction. Many churches, Salvation Armies, and other programs like that also can assist with rent and utilities if you get behind. And your local Department of Social Services is a good place to start. They can help you point you in the right direction, even if they don't have assistance themselves. So last month I used the full hour and a half, but I think I had more questions last month. Kane, are there any other questions or anything I can answer for anybody?
We don't have any more questions in the Facebook.
All right. Well, I'll hang out for a minute and see if there's any other questions here, but thank you all for your attention, and I hope that this was useful. You know, feel free, as I said, you can get hold of Legal Aid of North Carolina. We will do another one of these presentations in about a month. And then I also encourage you to check out our YouTube channel. If there were specific topics that you'd like to see presentations on, you can let us know. We have some great short videos on specific issues like the CARES Act or the CARES Act, I'm sorry, so security deposits, all sorts of short videos that can answer some of these questions. I see a question here in the chat. In addition to calling social services, are there any other places we should reach out to if trying to find assistance for rent in Durham specifically? I would definitely contact DSS. There's going to be, in Durham specifically, there's going to be an additional appropriation through the CARES Act that is going to come through the city. And we don't know yet who's going to actually be administering those funds, but it will probably be the County Department of Social Services. And that, I think, is going to be close to $1 million, $900,000 or $950,000. So there should be a substantial amount of money. I think it'll have a cap. It'll only help cover 3 months of rent. And it may be a cap of about $5,000 in total for any one family, but there should be some pretty substantial assistance coming. And I know that other counties have had similar programs and have been, there should be some substantial assistance. So you can also contact Legal Aid of North Carolina in Durham. We can help direct you. There's another question here. Let's see. Will folks who are not citizens qualify for that CARES Act money? I don't know. I can tell you that the eviction diversion money in Durham that has been appropriated by the county does not require that you be a citizen. It only requires that you be a resident of Durham County. And we're still figuring out exactly what the requirements are going to be under the COVID money. Unfortunately, because it's CDBG money administered through the federal government, I suspect that there may be some sort of citizenship requirement on it, but I'm not sure. I also see in the chat, churches, Salvation Armies, Catholic Charities, those are all great places to go. There are a number of churches in Durham that help. Alliance also has emergency rental assistance. That's the mental health care provider. Any financial assistance for rent in the Raleigh-Cary area? Yes, I know that Wake County and the city of Raleigh are going to be having financial assistance through the CARES Act, and some of that is not in place yet, but your County Department of Social Services will be able to direct you in Raleigh and Cary as well. Thanks. When will those funds be available? I don't know yet, but I will make sure to keep we will publicize that when those funds are available, as far as that additional CARES Act funds. There's another question in here regarding the 10-day appeal time frame. You mentioned that the tenant has to post a bond or pay the rent for that time. They cannot pay. Is it automatic that they must vacate during the appeal timeline? So generally the judgment in small claims court, if they don't stay that. So in order to perfect the appeal, you do not have to pay a rent bond. The appeal is still valid, whether or not you pay the rent bond. But if you don't pay the rent bond, then the decision is not stayed, and the landlord can go and get a writ of possession from the court. You can file a motion to modify the rent bond. So if you think that the rent bond ought not be required for some reason in that specific case, then there is a procedure to file a motion to modify the rent bond. But you usually have to have some legal basis or some argument to say why the rent bond ought not be required. Now, because the rent bond is not required to perfect the appeal, but only to stay the enforcement of the small claims court judgment, if, say, the tenant loses in small claims court and they appeal, but they don't pay the rent bond, and then the landlord gets a writ of possession issued and takes possession, the district court, if the tenant wins the appeal, could restore the tenant to possession. So the landlord would need to be a little bit cautious while the case is still proceeding in district court. If they get a writ of possession, I would not advise a landlord to re-rent that home, because that case is still live and they might lose on appeal, and the tenant could be restored to possession. All right, Orange County Housing. There's some great information in the chat here about how to get some help with a housing helpline in Orange County, which is fantastic. Churches.
Hey, Peter, I just want to read that out because the people on Facebook aren't going to be able to see that.
Please do, yes.
So in Orange County, people can call the housing helpline. It looks like the number there is 919-245-2655. It's open Monday to Friday, 12 to 4 p.m. and Sunday to Thursday overnights from midnight to 6 a.m. or email housinghelp@orangecounty.nc.gov. I'm just going to post that whole comment over on Facebook as well so that people can see it there.
Thank you, Blaine. And there's been some exciting conversations happening in Orange County about launching an eviction diversion program, possibly something similar to what we have in Durham. I know there's been similar conversations in Winston-Salem and Greensboro and Wake County. So we're excited to see that a lot of local governments across the state and in Wilmington have been discussing and making some commitments to helping tenants who are facing eviction, not just during COVID, but more broadly. So anyone know church is currently still helping with rent payment? They were doing financial support, no longer able to assist because of being overwhelmed with requests. Yeah, I think that's probably true. So I don't have up-to-date information. I could list churches who I know who have done it historically, but I don't know as of today. Assuming that a tenant lost the summary ejectment action must leave. The same appeal time still in play if yes, it's always 10 days to appeal, regardless of the basis of the eviction. All right, I think that is all the questions that I see. Is there anything else in Facebook that I should address?
I don't see any more comments in Facebook.
Well, thanks everyone for sticking with us this afternoon. And again, I encourage you can, we do these presentations every week on different topics, and there's some excellent videos up on our YouTube channel. So I hope you'll check them out. And thanks so much for being with me this afternoon.
Thank you.
Kane and Blaine, do you want me to hang out for the next 6 minutes, or are we good?
No, I'm not seeing anything more coming in. I think we can end it there.
Yep.
All right.
Good. Thank you.
Excellent. Have a great afternoon, everyone.